We're going to continue now with the panel on fixing elections. So just to remind everybody briefly about the ground rules, we're allowing each presenter 10 minutes to present their amendment, followed by 5 minutes of commentary from each commentator, hopefully leaving time for questions at the end. So just briefly, for introductions, on my far left is Russ Feingold, visiting professor at Stanford Law School and, of course, former U.S. Senator. Next to him is Richard Pildes, professor of law at NYU Law School, and next to him is Zephyr Teachout, professor of law at Fordham School of Law. Great. So, Russ, please.
Thank you. I've introduced two seemingly unrelated amendments to the Constitution, but will argue that they are actually interrelated and should both be adopted. The reason is to correct the imbalance in the current Constitution that, in my view, undermines the principle of one person, one vote, but it does not eliminate the requirement in the Constitution that each state shall have equal representation in the United States Senate, as is protected in particular in Article 5, and I still, as I will suggest, believe that is an important check on pure majoritarianism. But I do want to say that I propose these to be done through the traditional congressional Article 5 process and not through a constitutional convention, which I oppose, but have enjoyed being in a room for the first time in my life with a whole bunch of people who think it's a good idea. The two amendments are, they've been introduced several times. One is the simple one most recently introduced by Senator Boxer of California to eliminate the Electoral College. The other is my own amendment from 2009 relating to the 17th Amendment to require that vacancies that occur with regard to the United States Senate be filled by popular vote, not by gubernatorial appointment. My hope is that the combination of this will move us in the direction of ensuring that the votes of all Americans count the same when it comes to electing 1, the president, 2, the vice president, and 3, a senator from your own home state. And these, of course, are the highest elective offices that people get to vote for in our system of government. Let me begin with what appears to be in some ways only a perfecting or correcting amendment, and that is the one to require the vacancies be filled by popular election. I think this completes the purpose of the 17th Amendment, which of course was the amendment that required the popular election of senators rather than the original constitutional provision that had state legislatures doing it. In the post-Civil War era, as many of you know, this became very controversial. It became difficult to determine in some states, and then ultimately there were enormous accusations of corruption in the state legislatures about how they went about choosing these senators. It culminated in particular with activism in the state of Oregon, where they tried to actually bind state legislators when they ran that they would vote for certain people for United States Senate. And then it actually was part of an expose in Cosmopolitan magazine. William Randolph Hearst and his minions had a series of articles that came by David Graham Phillips called The Treason of the Senate, which became a book where basically they identified all these corrupt guys, particularly in Rhode Island, and the way they went about providing for how a senator was elected. And much of the material in the book is about the malapportionment within particular states leading to an unfair result in terms of who got to be the senator. So that also had one person, one vote implications even at that time. As was pointed out yesterday, this is part of that progressive era where a number of constitutional amendments were adopted. In fact, the 17th Amendment was one of the first amendments ever adopted, even in the entire 19th century, during the 19th century and the early 20th century, with the Reconstruction Amendments being, and the income tax ones being the only ones before that. I believe that it fundamentally altered one of the fundamental ideas of the founders. I think it was a big fix, if you will, to decide to have senators elected directly. And I believe that it was also, I understand it was also done because it was imminent that there was going to be a constitutional convention called that would have succeeded in implementing this provision. So it has a lot of relevance to this. So fast forward to 2009, Barack Obama gets elected. All of a sudden, he, Joe Biden, and 2 other senators become part of the administration. We have 4 vacancies suddenly. And instead of being chosen by popular vote, which of course has always been the case for members of the House, it's required by the Constitution, they were filled by governors, very famously in Illinois, with Mr. Blagojevich. And I would say that in all cases, you ended up with pretty good senators, but the reality is it wasn't the people of the state choosing it. It was one person, and it gave that person a tremendous edge in getting a permanent position in the Senate, and I believe it is time to complete that. So the Second Amendment is of course, getting rid of the Electoral College. I regard it as similar to the 17th Amendment. It's another decision to correct the original Constitution in favor of the popular will. I think that the Electoral College is at least as anachronistic as the notion of electing senators by state legislatures. And in fact, Jack and others are far better to talk about this, but I understand that the Electoral College was not exactly formulated off of the pages of Montesquieu and Locke, but was after a series of very difficult procedures and sort of almost slapped together at the end. I defer to you on that, but it was not something that was a fundamental principle or vision of the founders. In fact, it ended up being one of the first things that had to be fixed. It didn't work. It was set up in a way that because they voted for the president and the vice president, Jefferson and Aaron Burr were tied, would have been tied. And so one of the very first amendments, the 10 Bill of Rights, the Sovereign Immunity Amendment, the 11th, the 12th is already having to fix the Electoral College. It had to be fixed right away, and so certainly did not have some sort of a central founder's notion of it being something that needed to be exactly the same over time. And so I think there are a lot of arguments why this should go. Obviously, I am deeply influenced by the way things have been going with regard to the Electoral College lately. I will confess to being shocked that 2 out of the 3 last presidents were elected with less than a majority of the popular vote. But let's remember a few aspects of this. First of all, the Electoral College was based on also on the 3/5 man rule. States got more electoral votes because they were able to count slaves. That's how they got their congressional representation. That's how that was determined. So that has a dubious legacy. I think it's very questionable that the founders anticipated the notion of winner-take-all electoral votes within each state. 48 out of the 50 states have a winner-take-all procedure. I don't think that comports with anything that the founders particularly perceived and has an enormously bad impact, so bad that Hillary Clinton decided she had Wisconsin in the bag and decided not even to show up because it was a winner-take-all situation instead of trying to get her share. So I have some feelings about that as well. I think it doesn't comport with the notion of a democracy in the 21st century. One of my jobs, I had to go and try to talk people in Congo and other places into following their election procedures and to go for the popular vote. And here we are with a system like this that doesn't make sense to the rest of the world. And the notion that you will hear that, well, this is going to cause certain states to be ignored. I'm sorry. Do you think Wyoming or Kansas get any presidential visits? No. People don't come to California except to take your money, because particularly in this area. So this idea that somehow this creates a rational process, what it really is a bizarre situation that the founders could never have anticipated, that you could fly to 7 states in one day and just go to those 7 states and game it. This could not possibly be something that the founders of this country thought about when they initiated this. Let me conclude by saying I do not believe we should go the whole route. I believe that the Constitution, actually under Article 5, prevents us, under the current Constitution, from getting rid of equal representation in the United States Senate. That is actually unamendable under Article 5 of the Constitution. I know some doubt it, but that's how the language reads to me, that you cannot change that without a constitutional convention. But I still believe that that has its role in providing balance, in protecting federalism, and legitimate states' rights, so I don't think we should eliminate that, but I do think these 2 steps would be important steps in the right direction. Thank you.
Thanks, Russ. And now we'll hear commentary from Amy Wax, University of Pennsylvania.
Thank you. I'm going to focus on the proposal to abolish the Electoral College for presidential elections. And I should say, by way of the usual disclaimer, that I know absolutely nothing about the Electoral College, so we're really working with a blank slate here. In response to something that Rick Pildes said yesterday, I would open with an anecdote from my college days. One of my best friends in college was a philosophy major and went to his advisor and told his advisor that he wanted to write a senior thesis on free will and determinism. And his advisor, also one of my professors, said, oh no, not that old saw, not that old saw. So I guess I would say the same about the proposal to abolish the Electoral College. That proposal is a perennial old saw. It is floated and debated periodically and regularly, usually in the wake of a presidential election like the one we just had. And we've had a number of them, as Senator Feingold says, where the popular vote and the electoral vote are at odds, and that certainly is jarring to many people. But I think where one stands on the Electoral College is often just a function of where one sits, right? Whether the outcome is something to cheer or bemoan, whether you think that reform will preserve or change what one considers a desirable state of things, and I readily concede that my own take on it is somewhat influenced by that. The detractors of the Electoral College, and that, by the way, includes our own President Trump, who tweeted in 2012 a sharp-edged criticism of the Electoral College as an anachronism. I have one powerful and popular principle on their side: one man, one vote. What could be more appealing? It's like motherhood and apple pie, very hard to stand against one man, one vote. But the defenders, who have included, among others, Richard Posner in a widely read 2012 column in Slate, as well as others, point first and foremost to what he considers the founders' concerns. We could quarrel with that, I suppose. Their desire to make the president, quote, and this is his term, everyone's president, by ensuring that no region, no parochial sectional interest, however populous, has enough votes to capture the White House to the neglect of others, right? The idea is that smaller states need a voice, need somehow to have more influence and more heft than the popular vote would give them, lest they not be forgotten. Now, whether things actually play out this way is very contingent, it's very tricky. The Electoral College elevates the importance of swing states, for example, and of bigger states, because in bigger states, the prize is all the people who didn't vote for you that have to come along. So candidates will tend to focus their energy to take advantage of the winner-take-all, and they will pay less advantage to states which don't swing, right, that are either theirs or the opposing candidates. But the hope is that there will be enough swings to spread the attention and the influence around. That is, people from each party, each camp, won't cluster so much, but will reside more or less evenly throughout the country. But that brings me to the main point that I want to make, which is that the consequences of the Electoral College, or its abolition, are always a function of demography, of demographic patterns, or rather geographical demographic patterns, which are historically shifting and contingent. And right now, the most salient and I think the most relevant trend is one that Charles Murray calls our coming apart. And I don't know how many people have read Coming Apart, but I consider it one of the most important books to be published in the past 20 years, which everyone should read. And by the way, it is a book that is solely about white America, although he does have a chapter where he discusses minority geographical demography as well. And just as an aside, a bit of an anecdote, another anecdote, those of you who read the New York Times, and I assume that's a lot of you, will have perhaps noticed an article by Stephen Sessi and Wendy Williams in which they reported on a survey that they did of faculty. I think it included about 75 faculty from universities around the country, in which they sent them a passage and they asked them to rate that passage on a scale from conservative to liberal, conservative to progressive, blue state to red state, and give it a score. And the score it received was somewhere in the middle between the two camps. They sent it to me. They said, just read it, Amy, and just rate it, and then we'll tell you what's going on. I read it, and the minute I read it, I said, this is straight out of Charles Murray's Coming Apart. So I gave it a rather conservative score. I sent it back, and they later told me that of the 40 faculty members they had surveyed so far, I was one of only 2 who had actually read the book and recognized it as Charles Murray's book, Coming Apart. So what does that tell you? That tells you that there is very little awareness of demographic separation that is taking place. So I will be brief because I've run out of my 5 minutes. I can't really believe that. Upper SES people increasingly vote left, and they are increasingly concentrated on the coast and in the big cities, with a few sprinkled in the latte towns and big cities. Generally, distressed minorities join them, right? On the sheer numbers, the growth of higher education means that the balance is tipping towards these elites, and the middle of the country is being emptied out. Those are the less educated people. Right? So we have this enormous gulf here, which is between the gentry and the proles. Let's call it the gentry and the proles, okay? So the gentry live on the coast in the big states, the proles live in the middle. So to go from electoral college to popular vote means that, and we can argue about this, the proles will lose power, right? It will be easy to forget the forgotten man, to forget the forgotten man even more than the forgotten man is already forgotten. Now, I do not
We may have to continue arguing about it during the question and answer period. I apologize, Amy.
You're interrupting.
No, I'm trying. It's my job.
Oh, okay.
It's not me.
Well, just one more sentence. I don't believe it's healthy for the forgotten man to be forgotten any more than he's been forgotten. So I'm voting in favor of keeping the Electoral College.
Thank you so much. Next, we'll hear from Rick Pildes.
Thank you very much. So the purpose of my proposal is to draw attention to the most radical institutional or structural change we've made to the American democratic system in the last 50 years or so. It's a change that I think most of us are unaware of at this point. We take for granted the way we've done things since this change. I think we assume it's probably the natural way to do things. And it has to do with the way we select nominees for the presidency. So in the 1970s, we made the shift that continues to characterize the way we select nominees for the presidency. And the shift was to using a popular process in which primaries and caucuses become the way presidential nominees are chosen from the major parties. What I wanted to do is begin by describing a bit what the system was like before this change, since I think most of us have no memory of it or no consciousness of it, and then give you my proposal and why it's structured in the way it is. So the system that we had before the 1970s, for most of the 20th century, since 1912 or so, was a system that people characterize, or political scientists characterize, as a mixed system for choosing presidential nominees. There actually were some number of primary elections. They began with Teddy Roosevelt when he was trying to wrest the presidency back in 1912 and knew he had to go outside the party hierarchy to do that. So there was an element of popular primary decision-making, But the candidates were chosen through these party conventions in which party figures from throughout the country had the dominant voice ultimately in who the nominees would be. Let's see, I wanted to show you a couple of slides. Actually, I'm doing this because I want to get to the last slide. But let me show you a couple of pictures of how the system worked before this radical change in the 1970s. Can you get it up there? So for example, in the 1950s, this is 1952, in the Republican Party, there was actually serious competition between Senator Taft, who was more of an isolationist, more of a hard-line kind of Republican of that era, and Eisenhower. They actually had a very limited number of primaries, and if you look at the figures here, Taft did better in the primaries slightly than Eisenhower. And if the process is one like in the modern era, there's some reason to think Taft would have been the Republican nominee rather than Eisenhower, but the party leaders, in conjunction with these primary votes, decided Eisenhower would be a more effective candidate and more appropriate. You probably are very aware of John Kennedy and his role in winning primaries in the 1960s. If you have any memory of this, there's a very famous West Virginia primary where Kennedy established that he was a credible candidate, even though he was a Catholic, that Protestants would vote for him. But look how few the blue states are states Kennedy won in the primary. We still had a very limited role for the primaries. And this system involved what people call peer review, that potential nominees of the parties had to pass muster with people who had experience with them in government, who were able to judge their competence, and the like, along with some degree of popular input. So there were two tracks. An outsider track was possible by appealing to people through primaries, but there was also this insider role. Now, what happened in the 1970s is that in the aftermath of the 1968 Democratic Convention, we went almost overnight from that system, which involved a high degree of peer review, to a purely populist system in which the primaries and the caucuses controlled who the nominees were. And this system we actually created almost by accident. We stumbled into it. In the post-1968 Democratic Party, this famous McGovern-Fraser Commission was created to review the presidential nomination process. They proposed various reforms. They did not want to create a system in which primaries became the dominant mode of selection. This is one of the members of that commission, a political scientist. If you look at the line in red, we accomplished the opposite of what we intended. Overnight, we moved to a system in which peer review completely was eliminated from the process of selecting presidential nominees. It is this system, created in the 1970s, that has created a world, in my view, in which both less experienced nominees are able to become the major party nominees, in which candidates who actually are not really representative of the party are able to run. So in this election, of course, Donald Trump and Bernie Sanders were essentially independent free agents. Trump managed to capture the party label, but he's not really a Republican, or he was not one until, 5 years before he ran. Sanders, of course, is not actually a Democrat. He's an independent, and yet he came very close to capturing the party's nomination as a complete outsider to the party. And this is the world that was born out of this change. Here is what political scientists, at least one of them, two very famous ones, said when this change was made. The concern was that this new system might lead to the appearance of extremist candidates and demagogues who, unrestrained by allegiance to any permanent party organization, would have little to lose by stirring up mass hatreds or making absurd promises. That's why I said I wanted to build towards this slide. All right, so let me turn to my proposal. So the point of my proposal is that given how powerful the presidency is in the modern era, since Teddy Roosevelt, certainly since FDR, there's nothing more important to the functioning of the American government than the quality of the person who holds the office of president. And Arthur Schlesinger, in his famous book on the imperial presidency, concluded that all of the efforts to develop structural constraints, separation of powers, and the like really did not play a significant role compared to ultimately the quality of the person who occupies the office and the extent to which they've internalized various understandings about things like separation of powers and the like. The president, the framers were concerned about this issue of how you select potential nominees, but they didn't really have any vision or understanding or view about exactly how that process should work. They, of course, didn't even anticipate the rise of political parties. De facto, what happened for the first 30 years or so is that the congressional caucuses became the filtering mechanism for deciding who would run under the party labels. My proposal, the dominant strain of it, is to try to recreate, in a sense, the congressional caucus system, to build back in, what I'm mainly concerned about is building back in some element for peer review in the process of selecting nominees. So my proposal, the dominant strand in it, is to let the members of Congress, essentially from the parties, choose who the nominee will be through a congressional process. To ensure that presidents are not too dependent on Congress, once they're in office, an incumbent president, on my approach, has an automatic access to the ballot in the next election unless 75% of the members of the party in Congress veto him or her as the candidate. I decided that in a concession to modern sensibilities, I had to build in a second path. So there is a more popular path to nomination in my proposal. It's designed to require fairly broad consensus before someone who's an independent or a member not of the two major parties can run. I don't particularly have a big stake in what the threshold is. If people would want to make it higher, that's fine with me. I said signatures from 15 large enough states, 5% of the vote in the recent gubernatorial election. To avoid members of Congress who are sore losers in the competition for nomination from turning around and running and kind of fragmenting the parties, I put a sore loser provision in. So if you've been in office as a member of a major party in Congress for a year before nomination and you can't get it through that process, then you're out. Basically what this proposal does is in one fell swoop eliminate presidential primaries and the Electoral College. The vision here is that we would have a one-round election between nominees chosen through these processes. If no one gets 45% of the vote, there'd be a majority runoff election, a second stage, as in France. The purpose of the proposal more generally, not just in terms of drawing your attention to how dramatic this change we made was and how consequential the change was, but more generally, I'm trying to challenge what I have sometimes called in writing a certain ideology of democratic romanticism, by which I mean the notion that if we simply empower people to participate more and more directly in processes of selection and even of governance, we'll end up with a healthier, better democratic system. I think this is the progressive era, our modern progressive era. A lot of post-1960s political reforms are driven by this kind of notion. I think some of them have been good and productive, but I think some of them have been counterproductive. And I think that this is a very powerful example, in my view, the shift to the purely populist approach to selecting party nominees. Last thought, many modern, well-established democracies do not select party leaders through this kind of populist approach we have. They do have a much greater role for party figures in parliament or in convention. So to the extent you think this is the only way a democracy can select party leaders or party nominees, both within our own historical experience that's not that long ago and the experience of other modern democracies, some role for peer review is understood to be a healthy part of selecting nominees for chief executive. Thank you.
Thanks, Rick. We'll hear from Sai Prakash, University of Virginia.
Well, I'd like to thank Mike and Mark and the private monopolist / robber baron Leland Stanford. I favor a convention of the states, but I'm really happy to note that Rick hasn't changed the vesting clause. It's still there, and so I will still be able to continue my work even after his amendment is passed. Rick alluded to the fact that it's elitist, and I think that's why Amy will love it. Just a couple of comments. I wonder, given the current composition of Congress and the fact that many members of the House are gerrymandered, and that produces particular types of representatives, whether we want hyper-partisans to make the selection of a nominee. Now, I know that the nominating process right now is controlled by people who are deeply interested in who the president is, and they are hyper-partisan as well. But I wonder if members of Congress are even more at the ideological extremes than members of the caucus and primary. And then I also wonder if Rick's solution or Rick's proposal really necessarily solves the problem he identifies. Because I can imagine that members of Congress, I could imagine a member of Congress from California saying, California is still going to hold a primary. I pledge to vote for the person who comes out of that primary. And so you've got this rule that says members of Congress decide, but you've got a sub-rule that's not constitutional that will then result in members of Congress deferring to what the populace wants. And so it doesn't really necessarily get Rick the expertise he wants, and that's what we have in the Electoral College today, right? The Electoral College was supposed to be these people that were supposed to, I think, decide on their own as to the fitness for someone for office, but that isn't what happens. I'd like to hear more from Rick about why the incumbent gets a special rule. I understand his point to be something like, well, we don't want them to be beholden to Congress, but I think members of Congress have a reason to favor the incumbent independent of whether the incumbent has been solicitous of Congress. And I think that's just the idea that you want to be able to say that your party has done good things. You have a hard time saying that if you're trying to get a new nominee. So I don't know why there's sort of an incumbent protection rule for presidential incumbents. And then two final comments. I kind of wonder what this would mean for sort of President Johnson or President Truman. Would they have been able to run again because of the sort of incumbent protection nature of Rick's rule? It seems like they're more likely to run because they don't have to worry about sort of a more open process. And the final point is just sort of maybe more administrative. The way that Rick has written the amendment, it talks about one nominee, and I'm wondering if the one nominee dies, what happens to the party? Do they not? They've got to be able to make another nominee, but I'm not sure there's a feature of Rick's amendment that makes that possible. Thank you.
Thank you, Sai. And last, we'll hear from Zephyr Teachout.
Thank you. Thank you, Mark. Thank you, Mike. I never thought that Michael McConnell would be the reason I got to meet Russ Feingold, but but that's pretty exciting. So I offer these as true drafts. And my goal in this anti-monopoly corporate concentration proposed amendment is twofold. One is to introduce what I think is a genuine threat to our liberties and freedoms right now with concentrated power as a topic. As you may notice, it is not part of the other panels, and so I'm cramming it into fixing elections because I do think it relates to our political freedoms. And so I propose these knowing that they have the advantage of being perhaps as brief as the original Constitution, but having all kinds of problems with definitions and exceptions. So I do think the sort of most basic dream of liberty is under threat. We have created a system that allows for excessive concentrations of private power, and then enabled the easy use of those excessive concentrations of private power to directly impact politics. Let me just tell you one story that I think helps express this. As you may or may not know, there are four companies that are responsible for 85% of the meat production in this country. Tyson is one of those. It's Cargill, Tyson, Smithfield, and JBS. So if you want to be a chicken farmer who sells to Tyson, first of all, if you want to be a chicken farmer, you're going to have to sell to Tyson or some other local monopolist. The country is carved up into areas where you can only sell to one distributor. There's only one distributor present. If you want to sell to Tyson, you have to use Tyson's feed. You have to use Tyson's watering mechanisms. You, as the farmer, take out the loan, the $1 million loan to build your chicken house, but have to use the specs in building the house and the lighting systems. And in fact, you have to use the eggs for the chickens provided by Tyson. Otherwise, Tyson simply won't let you sell to them. And you also have to sign a contract that does not allow you to talk with your neighboring farmers about what you are doing and about how much you are getting paid by Tyson. So we have a system that looks like an independent contractor system, but in fact reflects one company, Tyson, which regularly uses the information to experiment on its farmers, giving one farmer good eggs one week, another farmer another week, and learning from that, and then using that learning to profit itself. So there are a lot of concerns about what's happening in the chicken industry. And in 2010, Vilsack and Holder hold hearings around the country to say we've got to do something about the problem in the chicken industry. And here's where the real political problem comes. Farmers don't show up to the hearings. I personally have talked to farmers. I've talked to reporters who've talked to farmers, and there's been reporting on this in the Washington Post, who said, I'm not going to show up to a hearing where I talk about the problems with Tyson, because I'm going to get worse eggs after that. So you have a direct, politically chilled speech of these individuals. This is the kind of tyranny that our framers were worried about. We should be worried about it because it's a problem now, but it was certainly the fighting against the spirit of monopoly was part of our Tea Party protests, as well as the creation of our country. So they call this system, this chicken system, chickenization. And they don't call it that because it makes us all scared, but it does. They call it that because the beef industry and the pork industry really like this, and they're trying to take over this chickenization system. But I would argue that what we see is a growing chickenization in all our industries. Maybe you say, why should we care about a chicken farmer having his tongue cut out? Well, I think we should care about anybody having their tongue cut out in a democracy. But we should also care because this is the model of our major tech giants. So this has been long reported. If you want to be on Walmart shelves, Walmart gets to spy on your industry and tell you what needs to be in your product. Coca-Cola was told to switch its sweetener by Walmart so that it could have access to shelf space. Well, the key shelf space now is, for Amazon, it's you like this, you will also like this. The shelf space on Amazon is incredibly precious and powerful. And Amazon, like Tyson, uses its power, what economists call monopsony power, but this is broadly within what I would call the spirit of monopoly power, to then negotiate, have power over its different producers. So think about booksellers, publishers. They're the chicken farmers. And those booksellers and publishers, they are the producers of the ideas that drive our society. So when Hachette, the publisher, got in a fight a few years ago with Amazon over contract terms, Amazon would say, your books are going to be delivered 2 to 5 weeks later instead of the same day delivery. Effectively, they're getting treated like the chicken farmer being silenced. Now, so far, we don't have real evidence of Amazon chilling particular speech, but when I was pitching a story on this, and I kid you not, I have a new agent, but my last agent said, can you lead with something besides Amazon? No, serious, because the idea that Amazon itself would want to promote anti-Amazon activity is quite serious. So you should know that Google also does not have neutral search results, certainly Facebook. We are turning over and in the process right now, and I do think it's a constitutional moment in terms of how we are constituted, turning over a lot of power in our society to these private governors. And so one of the things that this amendment is intended to provoke you to realize is that government is not always that which we elect. That you can have private forms of government that dictate our speech, our thought, our behavior. Amazon can dictate to people selling drugs, just as Walmart can dictate what sweetener to use, Amazon can dictate what particular ingredients to use. We have granted this regulatory power to private industries. Jefferson wanted an anti-monopoly clause in the Constitution. He famously mentioned it in his letter talking about the First Amendment to Madison. Here's the problem: you don't have an anti-monopoly clause. Effectively, he was talking about patents at the time. But the important insight there is that he was concerned about publicly enabled private power performing a kind of governmental function. How much time do I have left?
3 minutes.
3 minutes, okay. They're non-monopolistic concentrated power functions that these monopolies then also play. For those of you who read the New York Times this morning, Google is taking over our classrooms, if you haven't. They are actively giving Google products for free in exchange for data. Certainly as candidates, Amazon, Google, and Facebook are massively upping their lobbying, massively upping their political engagement. My first campaign that I worked on was Howard Dean's campaign in 2004. I wrote an open source policy. The first thing I was told to do is just pass it by the Microsoft public policy people. Just pass it by. That doesn't mean they have a veto. But certainly within campaigns, if we think about companies having clusters of power, not just individuals giving money, we understand the excessive corporate power. My own position I've run for office a few times on education was a constant topic for people in the Gates network or other networks who would say, as a network, we aren't going to support you because of this. So these companies then play a role through individual contributions that's incredibly important. Briefly, and I do think these are deeply connected, the Second Amendment, the heart of the Second Amendment that I propose is that we need publicly financed elections. This is a structural fix. There's basically two ways to fund elections. It's either private or it's public. And there's the initial ways of privately financing elections was basically the system where the people, government employees would pay for elections. That stopped with the Pendleton Act and its other variations. But since the Pendleton Act, we've been struggling for how to fund elections in any kind of sensible way. And now we've moved to variations on the theme of privately financed elections has fundamentally structurally transformed what our Congress is. If you want to look at the function of this Congress, 40 to 70% of the time is spent raising money. That is the job. That is the talent. The sympathy, empathy, and intelligence of the people that we elect is directed towards finding the phrases that best suit the kind of people who can give over $1,000 in discretionary campaign contributions, which is a very strange, small set of people. And that if we want to have a representative government, this allows the states to experiment, and the federal government to experiment with different forms of publicly financed elections, but says that finally, like public education, and it draws its inspiration from state constitutions, which often include a requirement of adequate funding of public education, to say, this is a public function, and we need to make sure that our candidates are representative and not representative of donors. Thank you very much.
And now we'll hear commentary from Randy Barnett, Georgetown Law Center.
Well, thanks. But before I comment on Zephyr's amendment, I want to say something about Professor Feingold's continued references to Article 5 Constitutional Convention. Article 5 doesn't authorize a constitutional convention. It authorizes a convention for proposing amendments. So if you want to do a shorthand, it really ought to be called an amendments convention. The locution of a constitutional convention was actually sort of innovated by the John Birch Society and the Eagle Forum in trying to do scaremongering against a Article 5 convention to do a balanced budget amendment. And it then got picked up because it sort of invokes the runaway convention idea, Philadelphia, et cetera. So anyway, this is probably the most important thing anybody's going to take away from this conference on Article 5 conventions is that it should be called an amendments convention. Now, on to Zephyr's proposed amendments. I don't really necessarily have anything really interesting to say about these things because mostly I have policy disagreements with them, and I don't think my policy disagreements are particularly expert. I just have the same objections to these kinds of things that many of the people in the room might have. I will say this on behalf of the amendments that she proposes. They're mercifully short, and so I like that part. So that's the good part. Everything else I think I disagree with. I'll start with the monopoly provision, and obviously the issue really is what is a monopoly. She kind of referred to this problem of definitions. Here are 3 proposed amendments that were proposed by state ratification conventions to Congress, accompanying their ratification of the Constitution. Massachusetts proposed that Congress erect no company with exclusive advantages of commerce. No reference to monopolies there. New Hampshire and North Carolina proposed that Congress erect no company of merchants with exclusive advantage to commerce, by the way, which shows that commerce is about merchants. That's what the original meaning of commerce is about. And then New York says that Congress do not grant monopolies or erect any company with exclusive advantages of commerce. And so here you do see the introduction of the term monopoly. If monopoly were limited to government-granted exclusive privileges, I would actually be sympathetic to this amendment, and I would know what it meant. And I also am sympathetic to Lysander Spooner's argument that the postal monopoly is unconstitutional. The Constitution doesn't actually grant the post office a monopoly. The Articles of Confederation did, but the Constitution did not. So I'm kind of sympathetic to that. But if you're going to rely on modern antitrust theory to tell us what monopoly is, then I'm a little more skeptical that this is a feasible idea. What I took away from antitrust law as a student is that if you charge too little for a good, you're engaged in cutthroat competition. If you charge too much, you're engaged in price gouging. And if you charge the same, you're engaged in conscious parallelism. So it doesn't matter whether you charge too little, too much, or the same, you're guilty of an antitrust violation if they want to charge you with an antitrust violation. So that's antitrust law as far as I'm concerned. Even when we heard Zephyr's explanation of it, she easily slips into the monopsony terminology from monopoly, and the example she gave is an example of 4 companies controlling 85% of the chicken distribution business. So that's 4 companies, not 1, 85% of the business, not 100%, and we're off and running under this amendment. So that's my problem with the first provision. With respect to the second provision, I actually would have a lot to say about this. Again, completely uninformed by expertise. Which is just my views of these things. But first of all, I would say that I believe that expenditures are related to freedom of speech. If you don't think that monetary expenditures are related to freedom of speech, then I would just propose a rule that says that the New York Times cannot expend money paying their employees. That's certainly not a restriction on the freedom of the press. To prohibit the New York Times from paying its employees. Well, you all know that prohibiting the New York Times from paying its employees, expending money on its employees, is a restriction of freedom of press. There's a close connection to expenditures and freedom of press. So that would be the beginning of my critique. And the end of my critique, with my 1 minute left, is that under this proposal, it would make it constitutional. In fact, it would make it constitutional to criminalize political speech. Criminalizing political speech would be constitutional. This is not a hypothetical. In fact, it was arguably done in the case of Hillary the movie, which is the basis of Citizens United. It would allow you to criminalize a movie criticizing a political candidate, as long as it was within a particular window of time, and a book criticizing the candidate, because in fact, Solicitor General Kagan could not adequately distinguish a book from a movie, and I don't think it could be distinguished as a form of political speech. And so I'm against that on the grounds that it would inhibit political speech, and my 5 minutes are expended. I yield back the balance of my time.
Thanks, Randy. We do have time for questions. Please, Jane.
Okay, my question is for Rick. I'm wondering if you are overcorrecting for 2016. We had the 2 insurgents. We had the party takeover. And we've had the demagogic realization from the quote. But what is the track record that would lead you to say that the parties are not having enough say in who the presidential nominees are over the last several decades? We could talk about Obama. He was somewhat of an insurgent. I'm guessing that many Democrats in the room, including myself, were glad that he won, not Hillary in 2008, given what 2016 looked like. But what is the impetus for this? And is it overcorrecting for 2016? And one of the reasons the insurgents did so well in 2016 is just historic low regard for the parties. And I think much of that justified. So, wondering what you think about that.
Right, so on the last point first, so in something like the mixed system, the populist anger, alienation, frustration, you know, all of these grievances that are genuinely there would certainly still get manifested, and hostility to established elites and all of that. But what would happen is the combination of those forces plus the party role in choosing nominees would lead to carriers of that alienation and anger and the like, who also had, you know, a significant level of experience, who were viewed by peers as, you know, competent, who would represent to some extent not the fringes, but, you know, there'd be moderation, there'd be mediation. So it's not that that stuff would be ignored, it would just get represented by figures who, you know, I would say would be more appropriate. I do think there's been a systematic, this proposal is something I've been thinking about before 2016. I just think 2016 drives home in a pretty powerful way some of these concerns. I do think there's been somewhat systematic, not complete, but less experienced people who have gone in. Jimmy Carter, I think, would never have been selected through the old system. George McGovern probably wouldn't have been. This is being recorded, isn't it? So I better be a little careful about what I say next. But I think President Obama suffered from not having significant experience early on in his administration. And I think there were costs to that. So, you know, what I'm concerned about is with this system, what people prefer is novelty, lack of experience, not having had to take hard votes in Congress, and that there's both an issue of competence and also, you know, concern about the more extremes having greater capacity to go into government. That's my sort of sense on balance of the pre and post systems.
Sandy.
Yeah. Two very brief comments on Senator Feingold's and Rick's proposals. Senator Feingold's amendment, I think, solves one problem while setting up the possibility of an absolute disaster for another. That is, the problem it solves is of retail vacancies in the Senate, where a single senator dies or indeed takes position in administration, and the Senate can function quite well, even with 96 senators. This was the case in the Obama administration. But there is the possibility, of course, of catastrophic attack in a variety of ways in which we'd have wholesale vacancies. And we'd have the very same problem we have with the House, that if there's no way of replacing a wholesale set of vacancies in the House or the Senate on waiting for elections in 45 days or 2 months or whatever, then either we don't have a government or more likely we have a dictatorship. But it does seem to me that that it's very, very important to have in mind what it is you're trying to respond to. And the Blagojevich scandal, however much it was a scandal, is not the only thing one should be thinking about with regard to vacancies in the House and the Senate. With regard to Rick, there's a lot that could be said, and there's not time, but I'm curious if you've thought more deeply about the most curious and possibly unnecessary office in the executive branch, that is the vice presidency. Why not wait until you have the election for the successful candidate to name the vice president as under the 25th Amendment? Would the vice president be the recipient of the re-election bonus that you give to an incumbent president? I frankly see no reason in the world to give that sort of leg up to a vice president. But I'm wondering, if you've thought more fully about the whys and wherefores of this extraordinarily odd office that we've got.
Professor, not only do I agree with you, but I supported the continuity of government amendment by Senator Cornyn. I put it through my subcommittee for the circumstance you described. So my proposal does not preclude that. In fact, I think you probably should provide for that kind of emergency with regard to the entire Congress. So take it in good spirit, and I think we should do that as well.
So I know as a academic, I'm supposed to say I've thought through all of this very comprehensively and deeply, but I confess I haven't really devoted much thought to the office of the vice president. I do want to say about the incumbency protection. It's interesting that Cy said you don't really need it because it's overwhelmingly likely members of Congress will want to support their party's incumbent. So I don't know how much is at stake in it, but as I say, my concern was I don't want a president who is overly beholden to members of his party in the House and the Senate. So it's not like I think, incumbents should have some special preference because they're incumbents. It's a way of trying to deal with the founders' initial concerns. One of the selection methods they did specifically consider for the president was to have Congress choose. And they didn't want that because of the overdependency it would create. So I don't have a big stake in that, but that's what motivates the proposal.
Please.
For Professor Feingold, I'd like to hear your reaction to some of the comments from Professor Wax about whether abolishing the Electoral College would lead to an undue concentration of effort on the 62.5% of people in this country who live in cities. And then for Professor Teachout, question about the whole structure of the Constitution, and ordinarily it's state action that we're concerned with, right? We're concerned with the power of the government and the relationship of the government to the people, not the political power or the economic power of Tyson Foods or Amazon or any other large concentration of power, so long as they're not committing an overt act for which there can be an antitrust violation. The mere fact they have power doesn't mean it becomes a constitutional matter.
Thank you. Well, of course, I strongly disagree with this notion that the Electoral College's elimination would create this kind of elite situation. Look at the state of California. The people in the valley, in a place like Bakersfield, are essentially completely cut out of the current system. They're very conservative, but they have absolutely no motivation or incentive to get a stronger vote out of that part of the state because they know they cannot impact the process. If we got rid of the Electoral College, their votes would count the same as those elites who might be in this neighborhood.
So what I neglected to explain before is that at least as far as monopoly laws are concerned, I'm very sympathetic to Paulson's original meaning amendment, and that one of the things this is designed to do is to deal with the post-1981 destruction of our anti-monopoly laws by a combination of jurists like Scalia and scholars like Posner and Bork, who fundamentally gutted statutory anti-monopoly laws, whether it's the Sherman Act or the Clayton Act, in a way that I believe is then limiting our freedoms. And the fundamental sort of dream of America, I just want to repeat this, is the idea that we can be free people. And so whatever threats to those freedoms, it's part of our collective job, whether through Constitution or statute, to do this. I'm more inclined, honestly, to deal with this through statute, but since I wanted to sort of provoke thinking about the threat of private despotism, because it does feel like it's a private threat. So if you look at the introduction of the Sherman Act, Sherman not only talked about it as a charter of liberty, But he said, we will not endure a king as political power. We should not endure a king over production, transportation, and sale of any of the necessities of life. So in some ways, what I'm trying to do here is call on the broad anti-monopoly tradition within our country against the post-1981 destruction of that tradition.
Hi, thank you for the panel. So the title of the conference is The Big Fix, so I feel entitled to putting on the table an idea that I haven't heard floated yet, but I think would take care of the concern of some of you, and which I think are about reinvigorating the democratic core of the Constitution. And it's the idea of replacing the Senate, for example, with a randomly selected assembly of ordinary citizens, presumably. It sounds outlandish, but we were told at the beginning we're not supposed to be constrained by political feasibility, so I'd really like to hear what you think of it. I know it's discussed in Canada, for example. It's taken seriously in Europe. And it would save you the cost and time spent on elections. It would ensure a representative assembly. It would ensure a generalist assembly, if we think it's not a pejorative term. And we have some theories and empirical evidence to support the claim that they would be able to produce good policies. So I'm just curious to hear your reactions.
Absolute lunacy, in my view. I mean, that's a beautiful example of the absurd extremes of this romantic idea that if we can only have random citizens making government policy for us, the world would be much better. It's a devaluation of knowledge. It's a devaluation of experience. It's a devaluation of a variety of complexities that I think are, inevitably involved when you're trying to make policy on complex sorts of issues. There's this, part of the fantasy is, and I think maybe you're referring to this, there have been these experiments with what are called deliberative assemblies. So if you just bring in the right experts and let them lecture to people for a weekend or so, then they'll become knowledgeable and, make decisions and the like that's competent. I just think the entire impulse that's driving that is a deeply romantic and I think very dangerous kind of impulse, and that should be obvious from what I said. So that's my reaction to it.
I would be a little less harsh on this idea. In some ways, I think we're in the process of this experiment in our executive branch right now. But here I actually agree with Professor here that the regional issue, I don't know if you would deal with that in terms of representation in the Senate. If it was purely random, where there wouldn't be a sense of regional and other interests in the country being represented, I think that could create problems for a sense of a unified country. So that would be my first question.
So I think one of the reasons that people are sort of calling on the Roman tribunate and other examples of lottery is actually because of the concern of corruption. So that a way to get, they are drawn to a lottery because with a lottery then you don't have the fundraising. And so again, my second proposal, which is separate from overturning Citizens United or Buckley. It's just to say, let's deal with the problem of corruption in other ways than randomness.
Jamal. So a quick comment on the Electoral College and then two little detailed questions for Rick Pildes. On the Electoral College, it seems to me that that a state that wants to get more attention from presidential candidates could do so by selecting its electors proportionally rather than winner take all. So states have that option, and I'm not in favor.
Two have done that. Yeah.
I'm not in favor of the Electoral College, and obviously there are partisan considerations that would make it difficult for certain states to do that. But there's a broader point that I think needs more attention than it's gotten, which is what constraints, constitutionally or otherwise, there might be on the method of selecting electors, which is something that we haven't really grappled with, and I think we're going to probably have to grapple with pretty soon as various partisan proposals go forward. The two detailed questions for Rick. One is, I gather this is intentional, but there's no role for any party leadership outside of Congress. That seems likely to me to distort who gets selected as a candidate to someone. If you get 200 plus members of Congress, it's probably going to be a member of Congress who ends up being selected. Maybe that's a feature, not a bug, in terms of ability to negotiate the system and so forth, but certainly some of our best presidents have been outside of Congress or running on an anti-Washington agenda. The other detailed question is, the proposal appears to give the same weight within the party to senators and representatives, notwithstanding the different bases of representation, the different constituent bases. So might it be a good idea to, obviously politically difficult, but maybe a good idea to weight the votes differently of senators and representatives? That might respond in part to Cy's concern about gerrymandering.
So those are great questions. I agree with you completely that I actually would prefer to, figure out a way to structure it to build in a role for party leaders throughout the country, not just in Congress. I actually like the convention system that we had. It was a little hard to figure out how to draft that up into a constitutional amendment. And so, again, what I want to say is that the main point here that I'm trying to drive toward is figuring out a way to re-legitimate a role for peer review in the nomination process. And I don't have a particular stake in this form of the proposal. I agree with you, it would be better to build in a broader party constituency, and I'm happy to redraft this when and if our amendment convention takes place. And the same thing about, whether we should weight members of the Senate differently than the House. I mean, those are interesting features we could talk about, but this is all in the context of trying to stimulate a discussion in which people start taking more seriously questions about whether the system we now have is actually a desirable system for doing this, and whether we want to re-legitimate a role for non-random experienced party figures in government, whether in the states or in Congress, for filtering and mediating the various forces in a democratic system through the selection of particular nominees. So I appreciate those amendments.
Please.
Thank you. Roman Buehler with the Madison Coalition. I was the chief counsel for the election issues for the Republican majority from 1989 to 2001. And so I've spent a lot of time hearing about election issues. And my question is for Russ and for Zephyr. And by the way, I really admire your work and your passion for, reform, even if I may not agree with all the things you've done. But that's what we need. And my question is, if you nationalize the election, if you create a popular vote environment, somebody is going to have to make the rules for that environment. And I lived through the Nixon era, and I saw how the presidency can be used in ways that I didn't think were appropriate to dictate results that the president wanted that others did not. And if you end up with a uniform set of rules that Congress passes, inevitably those rules will have to be dealt with by regulation. And the regulations will be basically promulgated by a commission which under the Constitution has to be appointed by the president. And we've just seen a president remove, for whatever you want to call it, a very senior official in a law enforcement agency. President could use that same authority to remove somebody from a commission that they didn't like. And so if you nationalize the election, Zephyr, you talked about we should not suffer a king, right? If we nationalize the election and the rules are therefore defined by a set of regulators who are ultimately appointed by the president, are we not in danger of putting the chief executive officer of the country in charge of dictating and micromanaging the rules that govern that election? And isn't that the number one rule for election integrity? Don't put the incumbent in charge of the rules that govern their reelection. And I wonder how you respond and deal with that problem.
I think some of that is fair. Certainly, the president, of course, can only serve 2 terms. That would be relevant to the reelection of a president. But, it may require further reforms. I mean, the Federal Elections Commission itself needs to be, in my view, scrapped and turned into a completely different kind of agency that actually can enforce the law or perhaps promulgate these kinds of rules instead of having it be a commission that is controlled by the president. The FEC, in theory, is supposed to be somewhat independent and be able to act independent of a particular president's term. So I don't disagree with that. I also think we need, along the lines of Professor Schachter's presentation yesterday, I think we need a national Voting Rights Act for the 21st century that would guarantee across the board in this country certain procedures and certain rules that would be uniform so that people could feel that the process of popularly electing the president was a legitimate process.
So I think your colleague in McCain-Feingold said that of the FEC, and I don't quote exactly, that it was born, crippled, and then beaten to death.
Like him.
I just want to echo what Professor Feingold said, is that the FEC is the critical agency here, and there's different proposals, whether to make it a unitary agent head, and there's different ways to protect independence there. The language of independence, we can't be naive about it. Language of independence doesn't mean independence. But I think the core of what you're talking about is FEC reform, and FEC reform is required now regardless of whether you move to a national election. There's already a problem with a profoundly ineffective profoundly ineffective FEC that is subject to all kinds of political pressures.
Mike.
Can I, just one question for Zephyr, if you don't mind. I teach at Scalia Law School, the citadel of the destruction of the Sherman Act and all other antitrust laws were still added to this day. But what we all believe is that there are certain monopolies that you really have to be afraid of, which are the ones created by government. And the way I read Section 1, however created, might include the tobacco monopoly that we created under state auspices because otherwise the chief executives of Altria would all be in jail. It includes various taxi cab commissions, various monopolies created under state law, and on and on and on. Does this mean we're going to repeal the odious Parker Doctrine and all its adjuncts by constitutional amendment? If that is true, I'm all in favor, and I'm totally with you. And I want to ask Rick one question. It's completely naive, and I may have just missed this. Why is it not the case that the parties individually have an incentive to sort of restructure themselves and protect themselves against sort of complete outsiders by means of recreating it, right? There's no constitutional obstacle to doing it. It may be that all these democratic romanticisms and various sort of public choicey mechanisms prevent that, but would you preclude that opportunity or that possibility altogether? Is that why we need a constitutional amendment?
So thank you for the terrific question. And when I added, however created, I was initially just going to do the publicly financed election part, and then I thought, let's talk about big fixes. So there's a lot to be thought out. But what I was thinking about is the concern that right now a lot of our, the little antitrust law that is left after your benefactor had his way in Trinco and elsewhere, it really addresses itself, the last gasp is in mergers. And does not address itself to divestiture. And so that, especially with the tech monopolies, which I see as probably, in terms of government, the fear of private government, some of the greatest threats to the creation of private government, they didn't grow through merger, but rather through what you might call more organic growth. So that's what the however created was there. I mean, some of the traditional ways to deal with monopoly is to say, if we collectively choose as a country, or as a state, or that there is something that we choose, like we want to keep Amazon, or we want to keep the railroads, we want to keep methods of distribution which arguably you could put the taxis in, then we either turn them into something that is fundamentally under public control, or is subject to rules that require, all kinds of the traditional common carriage rules and other neutrality rules. That is one of the strategies, and I would not mean to get rid of that as a strategy to deal with times when the polity comes together and says, we choose to have this kind of dominance in this area. So I think the answer is, in some of your cases, yes, it would apply, in others not. But that's the problem with a very drafty amendment.
Can I just say, actually, I keep thinking about the public financing issue here, so let me just indirectly respond by bringing that back into the picture. I'd be very interested to hear how some of the more conservative, more libertarian kind of people in the conference here think about public financing. I understand why, the part of Zephyr's proposal that would allow regulation of spending and all of that is troubling to people. But just the straight-out public financing system. Trump campaigned on this anti-corruption agenda. He talked a lot about money in politics. And he actually said at a couple of points in his over the last few years, he made some gestures towards endorsing public financing, and then it all disappeared. Historically in the United States, sort of more right-wing populists, left-wing populists have actually united, in their fears about money in politics. And it's only in the last 20 years or so that the issue became quite as partisan in the way the divides work out. And I'm sort of was hoping there might be more response to that side of things. Michael, just in direct response to your question, yes, you anticipated my answer, which is I think the political culture has adapted to the institutional changes. And so it's come to be the case that we just take for granted that it must be this way, and it's very hard to change it back internally. The parties, with these super delegates in the Democratic Party, which were put back in after the debacle of Carter, they were specifically put there to try to build back in a role for peer review. But no one knows whether those super delegates in today's culture could actually exercise any meaningful voice because of how powerful the sense is that's developed that, no, Mike, that would be terrible. That's an offense to popular sovereignty. So that's why my thought is you need to jolt things with something that steps outside of that dynamic, like a constitutional proposal. Not that this is a real amendment, but yeah.
Jack.
Zephyr, I'd like to see you constitutionalize our right to a 3-pound chicken, something which is one can rarely obtain in any market. But my basic question, though, is for Russ, and then maybe secondarily for Rick. Russ, if I understand your proposal correctly, Congress, the final section of your electoral college or your presidential election proposal still gives Congress a lot of room to determine a number of aspects of how presidential elections would finally be determined. So one of the standard arguments against popular election is if you got rid of the state mechanism, which, and as you know, I would do this, if I were the lawgiver, I would do this tomorrow. But one of the standard arguments is we'd wind up with a kind of multi-party, multi-candidate election. It'd be very hard to get a majority, which actually was the framers' concern back in '77. But so I didn't quite understand where your proposal comes out in terms of what what you would find required. Or would you want to set a level of 40%, 45%? Would you want to have, what I think is a great idea,
40 or 45% for what?
Of the national electorate? Or
in order to become president?
In order to become president. Or would you want to have a second election?
My thought was a plurality, but that is not something I thought through.
Well, but would this be left to, maybe I'm misunderstanding your proposal, but wouldn't that be left to Congress to determine in the language of your?
No, not to my knowledge, no.
Okay. Well, then, in that case.
It would be a plurality. I've not gone to the point of discussing or thinking about whether there should be a runoff kind of situation. Yeah. I've not gotten to that point.
But don't you think, well, just follow up, don't you think that would be important to do ex ante rather than?
Yes. My goal here is to make sure that this is done by popular election, but I could see that as being a friendly amendment to try to fix that.
Marianne?
So my question is for Zephyr, and you spent most of your 10 minutes explaining the need for your various amendments, and I would like to hear more about how they would actually work in your view. Now, on the first one, you started giving an answer in response to Michael Glover's question, including that maybe you haven't thought it through. But I just look at it, and I'm just not sure what, on the day after it's passed, who is supposed to do what.
Yeah.
And I have a similar set of questions on the second. For example, do you, where between anticipating and rejecting the proposition that adequate and full public funding and appropriate regulation would distinguish in the amounts provided to or providable to various candidates based on things like their name recognition, their incumbency, and so on?
Great. So on the second one, I mean, there's been a lot of litigation about what constitutes an adequate education. It's hard litigation, but it actually arguably functions as sort of forcing states that have provisions that require fully funded public education to actually provide that. And there's been a raft of that litigation in recent years. So I imagine it working something like that, that states and the federal government have systems, and if those systems then seem inadequate, then it's challenged. But the question of media culture is absolutely essential. And one of the reasons we need publicly financed elections is, don't look at the presidency in a congressional race. We didn't know, but in the race that I ran most recently, we were estimating 20 to 25% of people were getting their news from local media. Most people are getting their news from paid media by super PACs or by candidates. The local media environment is so decimated that without publicly financed elections, unlike 50 years ago, I mean, this is a real difference, that we used to be able to rely on imperfectly, but the Manchester Union leader providing a daily check-in for a potential congressional voter in New Hampshire, and now that daily check-in doesn't exist. So that's one of the reasons for the need, and then looking at the media environment would be part of that analysis. It would be a complicated analysis, much in the way that education analysis. So the answer to your first question is, this is more like, I mean, the real danger with this clause is it's a Republican guarantee clause, and I'm a big fan of the Republican guarantee clause, but it hasn't worked out so well. So, but that it would not actually actively work to sort of force divestiture in most cases. There might be a tiny little sword, but in most cases it would be a way to interpret and to understand existing statutory. I mean, if we could just start by getting rid of the last 30 years of antitrust law and going back to an antitrust law that functioned pretty well from 1945 to 1981, which would not allow the kind of behaviors that I just described. That would be place one. And then it is a kind of spirit to inform and to question the kinds of mergers that happen. So it would be sort of an additional case in looking at a Comcast-Time Warner merger. Is this threatening private governmental control? So I do think there's more work to be done. I've thought a lot about more of this in the statutory area, but I am a little reluctant to bring the whole statutory weight into the Constitution, but rather say there's a missing principle in the way that we think about our current polity, and it's been missing in this conference, is that I think if you asked most people, they would talk about the threat of private power as one of the fundamental threats, and that's left-right. The fundamental threats to their sense of freedom and their sense of powerlessness, their sense of being unable to either speak, negotiate for a job. And so you're helping me even talking out loud. It's bringing that spirit back into our own understanding of our constitutional system.
We are almost at time, but Will, you have the last word, knowing that you're standing between all these people and their lunch.
There's some power in that. I think I might carry on a while then, just to see how this goes. I wanted to pick up this strain that Michael raised in his question to Rick about how we think about a constitutional fix to what is essentially an extra-constitutional institution. And I wanted to push back a little bit. It seems to me there are mechanisms that are available to parties to provide return to an era which I quite agree with you was a preferable system in how we think about the election and nomination of presidential candidates. A big reason why Sanders isn't the nominee is because of the superdelegates. There's no reason why the Republican Party couldn't bring on more superdelegates, whether or not you have a caucus versus a primary, big differences in whose voices are being represented and the views of the parties and the way in which they can discipline this process. So too, how they run their conventions. They have lots of options available to them. So what I'm wondering is, I'm all for this as a pitch, but why isn't it a pitch being brought to the parties rather than to a constitutional convention? And are there potential I worry in a kind of general sense, I haven't really thought this through, ways in which constitutional fixes on extra constitutional institutions may introduce certain perversities in how our parties more generally function.
Well, now I'm between you guys and lunch, so just very briefly. So I'm not sure about the extra constitutional issue and how significant it is. Most post-World War II constitutions do actually constitutionalize a role for political parties. It's somewhat accidental that we don't. I mean, we have indirectly through freedom of association, but because our Constitution is, so old and it was done before parties were anticipated as healthy aspects of democratic politics, they aren't constitutionalized. But I think the larger point you're making is correct. A lot of these things could be fixed internally. The reason I'm proposing it as a constitutional amendment is because we're at a constitutional big fix convention. But what I'm the reason these fixes don't happen is because we're in a political culture that is much more inclined to think about, random citizens, running the Senate than it is to think about re-empowering party figures in this kind of process. And so I'm using this as an opportunity to try to help build back a political culture in which it's acceptable to think and talk in the kinds of terms that you seem to endorse as well.
Join me in thanking our panelists and commentators.